Are you in the middle of a criminal case and you don't know if you qualify for a court-appointed lawyer? My name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing for about 7 years, mainly doing criminal and family law. I want to help you make law easy by talking a little bit about when and how you qualify for a court-appointed attorney. Um, it's not like most people think. A lot of people think that for any case in any situation, whether it's a divorce, a lawsuit, a crime, an adoption, they can apply for and get a free attorney. Uh, Unfortunately, that's not true. I've seen it in cases like adoptions or juvenile deprived cases where rights are on the line. Um, Someone could get a court-appointed attorney, or in this case, in a criminal setting, your rights and your freedoms are on the line. Then you qualify maybe for a court-appointed lawyer. The presumption is you have to be unable to afford an attorney on your own, which gets a little dicey when you're in situations where if you've been arrested and you've made bond, uh, you're not always going to be able to qualify for a public defender or a court-appointed attorney. There's a presumption that if you're able to afford a bond, then you should not qualify to get a public defender. There's actually a lot of argument about that. There's a presumption that's a pretty high presumption that if you can make a high bond, you're not going to get a court-appointed attorney because the law treats it as if you can afford that, you can afford to hire a lawyer. Um, in some cases, though, you still can. So you have to fill out what's called a pauper's affidavit. And a part of that affidavit, there's a specific section for you to fill out, or if somebody else bonded you out, for them to fill out, explaining why you should still qualify for a public defender, basically explaining why, even though they're able to pay, $500 to get you out on a $5,000 bond, they can't necessarily go and drop $5,000 on a lawyer. That doesn't always work, though. In the cases where the bond is set very high, it's extremely unlikely that the court is going to allow you to have a public defender. As an example, I just saw a case recently where a gentleman had posted a $50,000 bond. So either he posted the full 50K himself, or he hired a bondsman, paid 10%. That's still $5,000 that was paid, and he was trying to state to the court that he shouldn't have to pay for an attorney as well. He couldn't afford it, or whatever the case may be. The court just wasn't hearing it. The court flat out told him, either show up with an attorney or show up with a toothbrush, because we will revoke your bond and put you back in jail. Which ironically, at that point, then he could get a court-appointed lawyer if he was being held in custody. It seems kind of wild, and yeah, I've got stories for days about people who have tried and failed to get a public defender when they've been out on bond. It's kind of heartbreaking sometimes, and can absolutely be frustrating if you don't understand the system and the ins and outs of it. If you have questions about this, or if you've been denied a public defender but you still need legal representation, please call us. My name is Carl Burkhead, and I want to help you make law easy. Thank you.